Still no movement on the Seventh Circuit Court of Appeals case challenging Illinois' gun and magazine ban. It was heard several months ago in Chicago with a consolidated caseload from the Southern District of Illinois and the Northern District of Illinois challenging state and local gun and magazine bans. But here we are now, August 28th, and we still don't have a ruling from the Seventh Circuit Court of Appeals. And this while we're marching towards that January 1st deadline for people to register the semi-automatic firearms that the state legislature banned. So still a lot to be said about what that possible ruling out of the Seventh Circuit could be and what the next steps would be heading into a possible appeal from either side to the U.S. Supreme Court. Welcome back, Springfield's Morning News. After having the week off last week, appreciate everybody tuning back in, but let's get to the latest in that and other cases. So if we look at the docket, the last that we saw from the Seventh Circuit Court of Appeals dealt with a motion of the plaintiffs here to have the court, while they're anticipating a ruling sometime soon, who knows when, but they're asking for the court to consider a case out of Hawaii that ultimately said that butterfly knife bans were unconstitutional. So when you look at what at least the plaintiffs group from Barnett and Hood Guns and more and the National Shooting Sports Foundation, they ultimately spell out here that that Hawaii case confirms that Illinois House Bill 5471 violates the Second Amendment. And the argument which Illinois represents, the purported dangerous and unusual nature of a bearable instrument a state seeks to outlaw means that they are not arms, as the term is used in the Second Amendment. Rather, the relevance of a weapon's dangerous and unusual character lies in its historical tradition of prohibition, the carrying of a dangerous and unusual weapon. So again, that dangerous and unusual is what you see a lot in the arguments. But you've got the plaintiffs asking for the courts to consider that in their continued deliberation over what exactly is going to happen with Illinois' gun and magazine ban. But we talked about this whenever this happened, because this was earlier this month when the plaintiffs asked for the Seventh Circuit Court of Appeals to review the Hawaii case as part of their deliberation in the Illinois case. But you also had the Attorney General's office submit their statement saying that Teeter addresses a ban on butterfly knives, which the Ninth Circuit said resembles ordinary pocket knives Americans have used since the early 18th century. That decision provides support for plaintiffs' position that restrictions on assault weapons and large-capacity magazines, modern instruments used to perpetrate mass shootings, violate the Second Amendment. The plain text inquiry of Teeter, the Hawaii case, focused on a narrow question that has no bearing on this case, they say. So you could see kind of the back and forth there when it comes to the challenge against Illinois' gun and magazine ban. So we'll be watching that closely. Again, the docket, the latest entry was August 14th. So we're still waiting for any kind of indication as to when exactly they're going to release the ruling out of the Seventh Circuit Court of Appeals. But that's not the only thing that we're watching. We've got that lawsuit that was filed against the state's law that Governor J.B. Pritzker signed, allowing for the state to go after the gun industry for either allegedly making the public less safe, or for advertising to children, or for paramilitary purposes. And if we look at the latest in that docket, you'll see that indeed you had at one point the case was referred to a Judge Beatty. When it was ultimately filed, Judge Mark Beatty was assigned, and as we reported before, you had a different judge come in, Stephen McGlynn, and the new judge was ultimately assigned, and Stephen McGlynn, if you recall, he was the judge in the Southern District challenge of Illinois' gun and magazine ban that granted a preliminary injunction, and that preliminary injunction only lasted for about 6 days before the case was ultimately taken up by the Seventh Circuit Court of Appeals. But McGlynn took the case from Beatty, And that was earlier this month. But then you had a motion for reconsidering the judge. And that motion was granted last week. So Judge Stephen McGlynn no longer assigned to the case, according to the docket entry. The case is transferred back to Mark Beatty for all further proceedings and for future documents. So interesting to see that. That was, of course, after a motion provided by the state looking to ultimately have the reconsideration and to strike the designation of McGlynn from the case. But that order was ultimately granted with McGlynn no longer being assigned to that case. So interesting to see that play out as well while I was off last week. And that, again, that's the case challenging Illinois' law that allows for lawsuits against the gun industry for advertising certain ways or for allegedly making the public less safe. But the Illinois Attorney General Kwame Raoul, he's also been busy filing briefs in other states. In Delaware, in particular, he filed an amicus brief to support Delaware's ban on certain semi-automatic weapons. And in a news release, they called the Delaware law common sense. The Attorney General says that the Second Amendment to the Constitution does not prevent states from enacting reasonable firearms regulations, including those that restrict the possession of, again, unusually dangerous weapons and accessories to protect public safety, they say. So it's an interest balancing type of approach they're taking here. The full statement from Kwame Raoul, Illinois Attorney General, says, I support Delaware and its common sense laws to restrict access to assault weapons and large capacity ammunition magazines. Like Illinois, Delaware is actively protecting its citizens and communities from deadly firearms. He continued to say, I will continue to stand by fellow attorneys general who prioritize public safety by restricting access to assault weapons and large capacity magazines. So that's Illinois' attorney general. You've got the Missouri attorney general just across the river doing something totally different, because in St. Louis, the mayor is saying that she's going to enact an ordinance in the city of St. Louis that would, quote, prohibit military-grade weapons on the street and prevent the transfer of sale of guns to minors and prohibit insurrectionists and those convicted of hate crimes from having guns, according to St. Louis's mayor. But you had the Attorney General, Andrew Bailey from Missouri. Again, this kind of highlights, that's our neighboring state. Right, you got Illinois Attorney General Kwame Raoul defending Illinois' gun and magazine ban in the courts and defending other laws in the courts, while also filing briefs in Delaware and elsewhere supporting other states' bans on certain semi-automatic weapons. Then just across the river in Missouri, you've got an Attorney General that is putting St. Louis's mayor on note. And again, you've got St. Louis's mayor, Tashara Jones, saying that they're going to enact, quote, common sense gun safety legislation. But the Attorney General of Missouri said, quote, our state constitution guarantees the right of law-abiding citizens to bear arms shall be unalienable, and that any restriction on these rights shall be subject to strict scrutiny, and the state of Missouri shall be obligated to uphold these rights and shall under no circumstances decline to protect against their infringement. By this letter, let me be clear, I will zealously perform my constitutional duty to defend the rights of each law-abiding citizen to keep and bear arms in defense of their home, person, family, and property, which is the promise made to them by the Missouri Constitution. So this is also the same mayor in St. Louis who some private text messages came out where she was ultimately questioning the effectiveness of these types of gun restrictions, saying Chicago has strict gun laws as well, but that doesn't deter gun violence. So if you recall, we talked about that story when it was out several weeks ago. So again, just the latest in the back and forth of litigation and different types of measures that are being implemented elsewhere, and how one state's attorney general is going after the city of St. Louis for trying to, as they say, infringe upon individuals' Second Amendment rights, while Illinois' attorney general is not just defending Illinois' laws by getting a judge transferred back to handle one case and still waiting to see what happens in the Seventh Circuit Court of Appeals with the gun and magazine ban, but also going over to Delaware and making the case there for whatever laws that Delaware has in place that's being challenged. So a lot of moving pieces. Still no resolution, though. And we got to sit back and do some catch-up as to when we're going to see a Fifth Amendment challenge to Illinois' gun and magazine ban, because as I said, January 1st is the deadline to register those firearms in Illinois. If you had an AR-15 before January 10th of 2023 this year, you are going to have to register that by January 1st. The window for that opens up October 1st with the Illinois State Police crafting that registration scheme, and January 1st is the deadline. So what's going to happen? Are we going to see a Fifth Amendment challenge? Because you have a Fifth Amendment right to not incriminate yourself. And the argument that we've already heard is that you can't be forced to tell the government you have an item that the government has said is illegal. So if this is upheld by the courts and there's no Fifth Amendment challenge that goes through, what's going to happen here? So we'll be watching all of this closely and updating you as it happens. Here with Springfield's Morning News, I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk.